This conclusion entitles plaintiffs to judgment as a matter of law, as the court further finds no genuine dispute to any material fact. Summary judgment will enter against the United States. The challenge tariff orders will be vacated and their operation permanently enjoined. The President of the United States claims to have the authority to unilaterally levy tariffs on goods imported from any and every country in the world at any rate calculated via any methodology or mere cap price immediately with no notice or public comment or phase-in or delay in implementation, despite massive economic impacts that are likely to do severe damage to the global economy. If actually granted by statute, this power would be an unlawful delegation of legislative power to the executive branch without any intelligible principle to limit his discretion. But Congress has not delegated any such power. The statute the president invokes, the International Emergency Economic Powers Act, the IEEPA, does not authorize the president to unilaterally issue across-the-board worldwide tariffs. And the president's justification does not meet the standards set forth in the IEEPA. His claimed emergency is a figment of his own imagination. Trade deficits, which have persisted for decades without causing economic harm, are not an emergency, nor do these trade deficits constitute an unusual and extraordinary threat. The president's attempt to use the IEEPA to impose sweeping tariffs also runs afoul of the major questions doctrine. So is the IEEPA is separate than the law you were referring to, right? That's not the 70s law, is it?
Doesn't seem to be. I don't know why he didn't use this law. It literally gives president full discretion for unfair trade practices, which is what he's been claiming.
Yeah.
So
Well,
why didn't he use this thing? This thing would have more leeway. Then again, it's Trump.
did he? Wait, hold on. Okay.
Trade Act of 1974.
I thought the Trade Act of 1974 played a role. Okay. Yeah, I get. Okay. So it does reference it. Have to get there. Okay. On February 1st, 2025, the president issued executive order entitled Imposing Duties to Address the Synthetic Opioid Supply Chain in the People's Republic of China. The China executive order declared a national emergency posed by the influx of illegal aliens and drugs into the United States, applied to the Chinese government's failure to arrest, seize, detain, and otherwise intercept chemical, precursor suppliers, money launderers, and other TCOs, criminals at large, and drugs. Declared China's failure to act constituted an unusual and extraordinary threat, which has its source in substantial part outside of the United States to national security, foreign policy, and the economy of the United States. China executive order imposed an incremental 10% tariff in addition to existing tariffs on all imports from China. March 3rd, 2025, the president issued executive order entitled Further Amendment to Duties Addressing an amendment to that executive order, which doubled the incremental tariffs on imports from China to 20. As justification for the rate increase, it was stated that Chinese government had not taken adequate steps to alleviate the illegal drug crisis. On April 2nd, Liberation Day, the president issued executive order entitled Regulating Imports with a Reciprocal Tariff to Rectify Trade Practices that Constitute Too Large and Persistent Annual United States Good Trade Deficits, the Liberation Day Order. The Liberation Day Order imposed sweeping new tariffs at rates not seen since the Great Depression, including global 10% tariffs on nearly all countries in the world, regardless of whether they impose tariffs on the United States products, the rates at which they do so, or the existence of any trade agreements governing the relationship. These tariffs even applied to places with no civilian population or international trade activity, such as the British Indian Ocean Territory, whose only human inhabitants belong to a joint American and British military base on the island of Diego Garcia, Yar and the herd of McDonald Islands, which are inhabited only by penguins and seals. In addition to the global 10% tariff, what's up?
I think those ones were regulations on push-off points.
Um,
The
define.
reason why like those tariffs on weird uninhabited places, because companies can bypass tariffs if they say that they shipped off
Yeah, if they move
or transported a product to and then shipped off from that place, they can bypass tariffs.
Yeah, but I mean, it seems like they're accounting for that because they not only said with no population, but also with no international trade activity. Where was it? Yeah, these tariffs even applied to places with no civilian population or international trade activity.
Okay,
so it's saying that it doesn't have either. In addition to the global 10% tariff, the Liberation Day order levied much higher tariff rates on dozens of countries based on what the administration claimed to be an estimate of tariff and non-tariff barriers, but ultimately turned out to be a simple ratio of the trade deficit in goods as a percentage of total U.S. imports from a given country. The chosen formula is not an accepted methodology for calculating trade barriers and has no basis in economic theory. April 9th, 2025, the president issued an additional executive order entitled Modifying Reciprocal Trade Rates to Reflect Trading Partner Retaliation and Alignment, which paused the elevated tariff rates on most countries for 90 days while leaving the global 10% tariff in place for all countries. April 9th order did not reduce the tariff rate applied to the imports from China. Instead, it imposed a new higher tariff rate of 125% on Chinese goods in retaliation for China's imposition of its own tariffs in response to the president's imposition of elevated tariffs on China. The tariff rate imposed on China was later increased to 145%. April 11th, the president issued a memorandum entitled Clarifications on Exceptions under Executive Order as of April 22nd, 2025, as amended, providing clarification of allowable exceptions under the Liberation Day order. The memorandum states semiconductors defined as including products classified in various headings and subheadings of Chapter 84 and 85 harmonized tariff schedule of the United States are exempt from the tariffs imposed by the Liberation Day order. The statutory basis, the Liberation Day order, cites the International Emergency Economic Powers Act of 1977, the National Emergencies Act, Section 604 of the Trade Act of 1974. Okay, so it does cite the Trade Act of 1974. None of these statutes grants the president authority to impose these tariffs. The Constitution explicitly reserves Congress to the power to lay and collect taxes, duties, imposts, and excises to regulate commerce with foreign nations. Indeed, Title 19 of U.S. Code, Customs and Duties, is where one would expect to find such presidential authority, but it makes no mention of such authority. Congress knows how to grant the president tariff authority when it wants to. Under 19 U.S. Code 1862, the president has a clear framework for adjusting duties and import restrictions for the purpose of safeguarding national security. Yet the president has attempted to avoid this framework by stretching Congress's specific grant of emergency authority into general tariff authority. Other specific grants of authority to the president to impose tariffs in limited specific circumstances exist. The president may impose tariffs on other countries that have violated trade agreements, and the president may provide specific targeted relief to industries that need time to adjust to foreign competition pursuant to 19 U.S. Code 2251. The IEEPA presents that the president may investigate, regulate, or prohibit any transaction in foreign exchange, transfers of credit, between through to any banking institution to the extent that such transfers or payment involve any interest of any foreign country or nation thereof. The importing or exporting of currency or securities by any person or with respect to any property subject to the jurisdiction of the United States. Oh, interesting. Investigate, block during the pendency of an investigation, regulate, direct, compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of, or dealing in, or exercising any right, power, or privilege. I can't fucking, this means nothing to me. With respect to transactions involving any property in which any foreign country or national thereof has any interest by any person with any respect to property subject to the jurisdiction of the United States. The IEEPA further provides that these authorities may only be exercised to deal with an unusual and extraordinary threat with respect to which a national emergency has been declared for the purposes of this chapter may not be exercised for any other purpose. But the word tariff does not appear in the IEEPA, nor does any synonym or equivalent. No previous president has used the IEEPA to impose tariffs except for President Trump himself briefly during his first term in an executive action that was withdrawn before it was fully implemented or subject to judicial review. The unusual and extraordinary threat asserted as a national emergency by the Liberation Day order is not an emergency, is not unusual, extraordinary, new, unexpected, odd, or even surprising. According to the Liberation Day order, the president finds that underlying conditions, including a lack of reciprocity in our bilateral trade relationships, disparate tariff rates and non-tariff barriers, and U.S. trading partners' economic policies that suppress domestic wages and consumption, as indicated by large and persistent annual U.S. good trade deficits, constitute an unusual and extraordinary threat to the national security and economy of the United States. That threat has its source in whole or substantial part outside of the United States in domestic economic policies of key trading partners and structural imbalances in the global trading system. I hereby declare a national emergency with respect to this threat. In other words, the national emergency claimed to be unusual and extraordinary in this case is the existence of bilateral trade deficits in goods with some foreign trading partners. Trade deficits are not unusual or extraordinary. The U.S. has run a net trade deficit at most times since World War II and consistently since the 1970s. That necessarily includes bilateral trade deficits within many nations. Nor are any trade deficits an emergency or even necessarily a problem. They simply mean that some other country sells a lot of things that America wants to buy, or that its people are unwilling or unable to purchase many American goods. Moreover, trade deficits go hand in hand with capital surpluses, which increases investment in the United States. Section 604 of the Trade Act of 1974 provides that the president shall, from time to time, as appropriate, embody the harmonized tariff schedule of the United States, the substance of relevant provisions of this chapter and of other acts affecting import treatment and actions thereunder, including removal, modification, continuance, or imposition of any rate of duty or other import restriction. As a bookkeeping provision, it assigns the president the task of periodically updating the harmonized tariff schedule to reflect changes in policy that have occurred. It does not set out any power, authority, or process by which the president may unilaterally set such policies. Okay. The National Emergency Act provides the general framework for declarations of national emergency. It explicitly disclaims granting any substantive authority itself, instead requiring that when the president declares a national emergency, no powers or authority made available by statute for use in event of a national emergency shall be exercised unless the president specifically or specifies the provisions of law which he purports that he or other officers will act. Gives the president general authorization to delegate functions to subordinate federal officials. It has nothing to do with trade or trade regulation. This is just proving harm. It's just a bunch of U.S. companies. Presidential authority to unilaterally impose worldwide tariff, if Congress were to grant it all, must be granted clearly and unmistakably, not through some implication so vague and so indeterminate that it went unnoticed by every other president for nearly 5 decades. The IEEPA does not mention tariffs or duties, or at any point suggest that it is granted power to lay and collect such. There is no precedent for using the IEEPA to impose tariffs. No other president has ever done so, nor claimed a power to do so. The existence of trade deficits in goods and with other countries does not qualify as a national emergency. Courts are generally skeptical of newly claimed grants of authority discovered for the first time in decades-old statutes. Utility Air Regulatory Group, which the EPA is cited. Indeed, Congress passed the IEEPA to limit what it saw as presidential abuses of emergency authorities in years prior to 1977. Congress knows how to grant presidential authority to impose or adjust tariffs when it wishes to do so, and it already has done so in more limited statutes contained in Title 19 of the U.S. Code, but the president has decided to avoid the limits on his authority imposed by Congress to find new, never before seen authority under the IEEPA. This is about. Does it cover the? Okay. Okay. Thoughts? Prayers?
Interesting. Well, they seem to be correct.
So, well, I mean, the judge ruled in their favor, so.
Now, the court was probably incorrect when it comes to they're not supposed to rule on the merits of an executive decision, but
What
they
do you
were
mean?
definitely right because if courts were able to say like this executive decision was not merited, because that would mean that now the court is qualified to judge those decisions, rather than like the legality of it. Because in this case, now the court's acting as a economics expert.
Oh, okay. So it's like almost outside of like.
It's slightly outside the scope, because what they're supposed to pretty much do in this case is, you're not delegated this power, period. End of story.
Yeah. Which it seems like that's what they're doing, though, right?
Yeah, yeah. Well, they shouldn't have included like all the economic stuff at that point.
Oh yeah, sure. Like claims of economic harm or whatever. I'd imagine that was done in order to prove standing or to prove like to prove harm, so they could actually seek relief.
Yeah. The reason why is because we always want to because the court is always supposed to have no teeth in certain things. So if the courts were, Jefferson always talked about this, was that if the courts ever became the experts on stuff, then they would be the ones deciding everything.
Yeah. Sure. Yeah, but I mean, I can't imagine that using economic harm to prove standing would necessarily be.
No. That's completely valid.
Yeah, what we're talking about here. Yeah.
But now, if they use it to do like demerit like the Declaration and try and void that, then we might be getting into some gray area.
Void the Declaration. It depends on what grounds. On the grounds of like it being economically harmful, then yeah, sure, that's like way outside of what the court's supposed to do. But if they're voiding it,
it's like they're the ones being like, we're the economic experts now.
Yeah, sure.
This is now invalid.
Yeah, but they would have to basically rule that it was invalid just because it was economically bad, which I don't think is even close to what's happening here.
Yeah. They are definitely ruling based upon that it does not delegate the power, which is correct.
Which
I'm not I thought it technically does, but only actually they thought of this. They knew this. The Congress back then knew it. They knew what the president was going to do. They only made it for a 5-year term. that they made where you can only do it 5 years after the enactment of the date is that they delegated that power.
Wait, so they delegated a power, but only 5 years after the legislation was passed?
Only during the 5-year period
Or,
beginning
yeah,
on the date of the enactment of this act.
gotcha.
May
And then the
enter into
rest.
trade agreements with foreign countries, may proclaim such modifications or continuance of any existing duties, such continuance or existing duty-free or excise treatment or such additional duties as he determines to be required or appropriate to carry out such trade agreement. Except as provided in paragraph 2, no proclamation pursuant to subsection A2 shall be made decreasing a rate of blah, 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 of a duty below 40%.
So what is that saying?
So pretty much they just temporarily gave the president power to control tariff.
Gotcha. But that's
In
still
certain
not still
respects.
applicable.
That's no, it's already gone.
Okay, gotcha. I mean, I won't deny that. I don't know.
Unless the year is 1974.
It might be. Official presidential proclamation that it is now 1974. I will say that the person who wrote this complaint was a little catty for sure, but
oh, wait a minute. Basic authority for trade agreements. Whenever the president determines existing duties are. Oh no. I just noticed this thing underneath it. As amended through PL 1138, enacted December 22nd, 2023.
so.
That 5-year period might be now.
Oh. Well, what they're claiming here is that the 1974
Trade Act is not what's being used to put those tariffs into effect.
No, they said that that is partially what it was.
Yeah, but they said that it didn't give power, not that it was being used as that, as like the enactment part, like the authority being used.
No, they said as statutory basis, the Liberation Day order cites the IEEPA, the National Emergencies Act, the Trade Act of 1974. So they said that the EO cites it, but it basically says that the president basically just keeps the tariff schedule and that it doesn't delegate actual power. There's a bookkeeping provision. It assigns the president the task of periodically updating the harmonized tariff schedule to reflect changes in policy that have occurred. It does not set out any actual power, authority, or process by which the president may unilaterally set such policies.
Okay, so I'm trying to figure this out because this is really weirdly worded.
Yeah.
It adds in this temporary thing of decreasing a tariff or duties.
Well, I mean, it's possible that the judge goes over it, maybe.
I don't know.
You want to keep reading?
It's weird. Like, here, I'll send you the PDF. Like, you'll see. It's literally right at the beginning.
I say what we do here is read what the judge said, and then we'll figure it out.
Yeah, well, I sent you the law anyway.
Okay, cool.
It's literally just right there at the beginning, section 101, basic authority for trade agreements.
I'll check it out after this. Okay. This is what the court grants the plaintiff's motion for summary judgment and denies the plaintiff's motion for preliminary injunction as moot. Here's how it goes. The Constitution assigns Congress the exclusive power to lay and collect taxes, duties, imposts, and excises, and to regulate commerce with foreign nations. Question in the two cases before the court is whether the IEEPA delegates these powers to the president in the form of authority to impose unlimited tariffs on goods from nearly every country in the world The court does not read the IEEPA to confer such unbounded authority and sets aside the challenged tariffs and imposed thereunder. Early in the nation's history, tariffs were a key means by which the federal government raised money to pay wages and fund the national debt. The revenue-raising purpose of tariffs has declined significantly since the ratification of the 16th Amendment permitted the imposition of income taxes. Since then, with the increasing complexity and interconnectedness of global economic landscape, tariffs have served more diverse purposes, including restraining importations of certain goods, protecting American industry, leveraging negotiations with foreign counterparts. As global economic relations grew in volume and complexity, Congress saw a need for specialized nonpartisan assistance in administering tariffs. Congress accordingly passed legislation creating the United States Tariff Commission, later renamed the United States International Trade Commission. To provide this assistance, the Commission shall have the power to investigate the tariff relations between the United States and foreign countries, commercial treaties, the volume of importations compared with domestic production, consumption, conditions, causes, and effects relating to competition of foreign industries with those of the United States. The ITC is responsible for maintaining the United States harmonized tariff schedule, which sets tariff rates for all merchandise imported into the United States. The HTSUS, the Harmonized Tariff Schedule, itself is indeed a statute but is not published physically in the United States Code. Congress's enactment of the Harmonized Tariff Schedule provided that its terms shall be considered to be a statutory provisions of law for all purposes. In addition to forming the ITC, Congress has responded to the growing complexity of global economic relations by delegating trade authority to the president. These delegations have clear limitations that restrain legislative power over the imposition of duties over foreign commerce. What is done by the Tariff Commission and the President in changing tariff rates to conform to new condition is in substance a delegation, though a permissible one, of the legislative process. For example, in 1962, Congress delegated the President the power to take action to adjust imports when the Secretary of Commerce finds that an article is being imposed into the United States in such quantities or under such circumstances to threaten to impair the national security. Elon's tenure is up. The limit seems to have been hit, and the cool down seemingly started. Are you referencing like the Doge expiration date thing? What are you referencing?
His SGE status has expired.
So yeah, the like expiration date thing on his.
Yep. Like Doge doesn't expire. His position does.
Yeah.
He does maintain an advisor position though.
Wait, what was his position outside of being an advisor?
Well, he's a special government employee, which means he was able to. They use that in order to wiggle around having to get him confirmed by cabinet, by Senate, as well as to prevent him from having to like give up his companies. Also, because he didn't want it to be a permanent role. Because if they made him, or long-term role, if he had been confirmed by the Senate for like the USDS, then he would have had to give up his companies, go under more stringent things, and he already said that he didn't want to do it forever.
Well, I mean, because the government said in court filings that he was not employed under the USDS or with the.
He isn't. That's how they got around it.
He was just a special government employee.
Yeah.
Well, Dub, I feel vindicated. My debate with Grid and Pentuple, they seemed to think that there was going to be an extra, what was it, or like $100 billion found in the military-industrial complex. That didn't seem to happen.
The Doge project isn't done. Doge's thing isn't done. His tenure may be up.
When is Doge done?
Doge ends next year.
Oh, okay, that ends next.
Yeah, and July 4th next year.
I guess we'll see. Well,
And I think,
then by the end of
uh,
the fiscal year is what we're gonna,
yeah.
which it started in January.
Then, yeah. Oh, what is it? What is it called? Oh, the cuts that Doge has made is going to be apparently presented in a separate reconciliation bill or a separate budget bill.
Okay. Okay. Anyway, okay. For example, in 1962, Congress delegated the power to the president to take action to adjust imports when the Secretary of Commerce finds that an article is being imposed to the United States in such quality or in such quantity or under such circumstance to threaten to impair national security. This delegation is conditioned upon an investigation and findings by the Secretary of Commerce and agreement by the president. Section 301 of the Trade Act of 1974 requires the U.S. trade representatives take action, which may include imposing tariffs where the rights of the United States under any trade agreement are being denied, or an act, policy, or practice of a foreign country is unjustifiable and burdens and restricts U.S. commerce. The USTR may impose duties also where the USTR determines an act or policy unreasonable and or discriminatory and burdens or restricts United States commerce. This power is conditioned on the extensive procedural requirements, including an investigation that culminates in an affirmative finding that another country imposed unfair trade barriers. So let me look up. The oh boy. What's it called? The Trade Act of 1974?
Yep.
That's it? That's what it's called?
Yep.
Oh,
They
okay.
weren't very clever, huh? I sent you it in DMs.
Just trying to get a summary.
Oh, yeah. Well, I guess that doesn't give you the summary, huh?
Yeah. Um, so it looks like we're correct here. So the president has the authority to negotiate trade agreements, um, negotiate trade agreements without an amendment that Congress can approve or reject. Um, allows the president through the USTR to take action against foreign countries, and allows the president to impose temporary release if U.S. industry is under threat.
Well, there's no industry to threaten.
After an investigation and recommendation by the U.S. Trade Commission, the president decides whether or not. So it looks like the Trade Act didn't give the president any unilateral ability.
No, they can't do that.
Well, perfect.
That's against the delegation doctrine.
How? Does it like literally say that the president can't have unilateral
Statutory
authority?
requirements. It has to be strict and purposeful. To my knowledge, anyway. Like, that's the reason why, like, anything that's ambiguous delegation, like,
Mm-hmm.
if the president thinks that he can, so believes that the sky is not blue anymore, he can, declare war. Like, that's a violation of delegation of powers.
I wonder if
Or,
Well, it's been already litigated that it's not. I wonder if there'd be an argument that the AEA falls on.
The Alien Enemies Act.
Yeah.
Technically, deportations already fall under the executive. The thing that doesn't is
Oh, you're right, because that power is not delegated. It's
yeah, that's just executive branch power. What doesn't is their pathways to citizenship and all that. Oh, and naturalization.
okay. Anyway, um, uh, oh, good. In
Also,
nine.
it's Marco Rubio's birthday, apparently, or
Oh,
was.
happy birthday to the goat. We're kidding.
Well, it's still nice you wished him a happy birthday.
I don't mean it. In 1917, Congress passed the Trading with the Enemies Act to grant the president powers to regulate international transactions with enemy powers following the entry of the United States into World War I. The Great Depression then led Congress to expand the president's authority under the TWEA to declare states of emergency to exercise authority over international trade even outside of time of war. TWEA, as amended, grants the president the broad authority to regulate importation or exportation of any property in which any foreign country or national thereof has any interest. In 1974, the United States Customs Court, the predecessor to the United States Court of International Trade, heard a challenge to President Nixon's imposition of the supplemental duty on all duatable merchandise imported into the United States. August 15th, 1971, the government argued that President Nixon's actions were lawfully authorized by the TWEA. Wow, holy shit. Why is there so many ties between the Trump administration and the Nixon administration? It's crazy.
You don't want to know.
I already know. The U.S. Customs Court construed the TWEA so as to preserve its constitutionality and held that the TWEA precludes the president from laying the supplemental duties provided by Nixon. The U.S. Court of Customs and Patent Appeals, the predecessor to the United States Court of Appeals for the Federal Circuit, reversed the lower court's decision, holding that President Nixon's duties were within the power constitutionally delegated to him. Court reasoned that Congress, in enacting the TWEA, authorized the president during an emergency to exercise the delegated substantive power to regulate importation by imposing an import duty, surcharge, or by other means appropriately and reasonably related to the particular nature of the emergency declared. Shortly after this decision, following a review by a Senate bipartisan special committee, Congress reformed the president's emergency powers. As a part of this reform, the Congress cabined the president's power under the TWEA to wartime. Okay. Congress also enacted a new statute, the IEEPA, to confer upon the president a new set of authorities for time of national emergency, which both more limited in scope than those of the TWEA. So the TWEA isn't even in place anymore, it seems, basically. It's just been like amended out the butthole. And subject to more procedural limitations, including those of national emergencies. The IEEPA provides that the president may investigate, regulate, or permit. We already read this. Okay. We don't really need a timeline because we already kind of read it. Procedural background is not super necessary. Jurisdiction is not super necessary. Standing is not super necessary. More standing. Standard of review. Jesus Christ, 25 pages in. Okay. Underlying the issues in the case is the notion that the powers properly belong to one of the departments ought not be directly and completely administered by either of the departments. Because of the Constitution's express allocation of tariff power to Congress, we do not read the IEEPA to delegate an unbounded tariff authority to the president. We instead read the IEEPA's provision to impose meaningful limits on any authority it confers. Two are relevant here. Delegation of a power to regulate importation, read in light of its legislative history and Congress's enactment of a more narrow non-emergency legislation, at the very least does not authorize the president to impose unbounded tariffs. Worldwide and retaliatory tariffs lack any identifiable limits and thus fall outside of the scope. Second, the IEEPA's limited authorities may be exercised only to deal with an unusual and extraordinary threat with respect to national emergency, has been declared, and may not be exercised for any other purpose. As tracking the tariffs do not meet the condition, they fall outside of the scope. As the tracking tariffs do not meet that condition.
Wait, didn't they already litigate this under Nixon?
Because of what we just read?
No.
Because it seems like the IEEPA was passed after Nixon.
Yeah, because Nixon used TWA, right?
Yeah. So
and
this
the IEEPA is supposed to be the peacetime equivalent, right?
Peacetime. So he used the TWEA, right? Or the EA?
TWE.
Whatever. He used that. And then I think it was permissible, or like it was ruled permissible under the courts, and then it was regulated by the Congress, and they passed two things: one to amend that, and then the IEEPA to serve in peacetime. But I think both of these were amended by Congress after the initial challenge by Nixon.
But it doesn't seem like they removed the tariff power. It seems like they just moved it to a different procedural thing.
Yeah. But the argument here is that Donald Trump didn't follow the procedure, I believe. And that this doesn't meet the extraordinary, unusual, and unusual threat thing. All right. Plaintiffs in both cases argue that the words regulate importation do not confer the power to impose tariffs. Any other interpretation, according to the plaintiffs, would run afoul of both non-delegation doctrine and major questions doctrine. The government counters that the words regulate importation have the same meaning that they did in the TWEA, an older statute that was found to delegate a power to impose tariffs. Plaintiffs are correct in the narrow sense that the imprecise term regulate importations under any construction that would comport with the separation of power underpinnings of the non-delegation and major questions doctrine does not authorize anything as unbounded as the worldwide and retaliatory, oh my god, tariffs. I have a stutter. I don't know where, I just developed a stutter out of nowhere. I don't know where the fuck this came from, but it's crazy. I was like,
that's a bit weird.
It's
strange.
The
same language.
I don't know.
Legislative precedent takes that's when legislative precedent kicks in. I might have gotten that one wrong by or misread that one, and then they probably you still probably violated it because you didn't follow the process. It's very likely that, but I'm pretty sure that legislative precedent takes effect due to the same wording.
Maybe. We'll keep reading. They cite the case Jennings v. Rodriguez. When statutory language is susceptible of multiple interpretations, a court may shun an interpretation that raises serious constitutional doubts and instead adopt an alternative that avoids these problems. The court in Yoshida 2, which is the Nixon case, recognizes that a case involving a claim to such unlimited authority might arise, observing whether a delegation of such breadth as to authorize the tariffs would be constitutionally embraced is determined by the same nature of particular surcharge herein and its relationship to other statutes, as well as its relationship to the particular emergency confronted. That case has arisen here. Let me read that. Whether a delegation of such authorize the tariffs here would be constitutionally embraced is determined by the nature. Oh, so they're saying that it's determined by the nature of the particular surcharge, its relationship to the statutes, and its relationship to the particular emergency. So it doesn't seem like this is actually contradicting Yoshida.
Does the statute say that it has those limitations?
It has what limitation?
That it has limitations based on the extent.
No, but it's saying that like there are other cases that may arise that have a different relationship either to the statutes, to the surcharge, or to the emergency.
So it seems like they're being just better safe than sorry.
Yeah. But I'd imagine that they're saying that it comports with, I mean, probably all three. And then they say that a case has arisen here. So they're saying that that the other case basically left the door open. The Constitution provides that all legislative powers herein granted shall be vested in the Congress of the United States. Congress is empowered to make laws necessary and proper for carrying into execution its general powers. The Constitution thus establishes a separation of powers between the legislative and executive branches that the framers viewed as essential to the preservation of individual liberty. To maintain the separation of powers, the Congress manifestly is not permitted to abdicate or transfer to others the essential legislative functions with which it is thus vested. The parties cite two doctrines, the non-delegation doctrine and the major questions doctrine, that the judiciary has developed to ensure that the branches do not impermissibly abdicate their respective constitutionally vested powers. The non-delegation, doctrine, Congress must lay down by legislative act an intelligible practice to which the person or body authorizes to such rates is directed to conform. Give that one more once over. Lay down by legislative act an intelligible principle to which the person, body authorized to fix rates is directed to conform. So it just needs to be. Statute lays down an intelligible principle when it meaningfully constrains the president's authority. The doctrine applies in extraordinary cases in which history and the breadth of authority that the executive branch has asserted and the economic and political significance of that assertion provides a reason to hesitate before concluding that Congress meant to confer such authority. So they're basically saying that, like, if there's question over whether or not Congress abdicated this authority, they probably didn't. That's kind of how I'm reading that. Plaintiffs and some. What did you want to say something there?
Oh no, sorry.
Plaintiffs and some amici, AMICI. Argue that the government's interpretation of the IEEPA into an impermissible delegation of power because the president's assertion of authority here has no meaningful limiting standards, essentially enabling him to impose any tariff he wants on any country at a time for virtually any reason. True. Similarly, plaintiffs suggest that Congress's use of the words regulate importation does not indicate a clear mandate necessary to delegate such unbounded authority to the president to make decisions of vast economic and political significance. The government counters that the IEEPA contains sufficient limitations. The president must declare a national emergency. The emergency expires after 1 year unless renewed. The emergency must be declared with respect to an unusual threat. Powers must extend only to property in which a foreign country or foreign national has an interest. Those are all not meaningful regulations, saying the president has to declare a national emergency, which he can do over anything, and he has to renew it once a year, which is just an executive order declaring the same national emergency over the same nothing, and it has to relate to a different country. That's not regulating the power at all. The separation of powers is always relevant to delegations of power between branches. Both the non-delegation and major questions doctrine, even if not directly applied to strike down a statute as unconstitutional, provide useful tools for the court to interpret statutes so as to avoid constitutional problems. These tools indicate that an unlimited delegation of tariff authority would constitute an improper abdication of legislative power to another branch of government. Through the major questions doctrine, or simply with separation of powers in mind, any interpretation of the EEA that delegates unlimited tariff authority is unconstitutional. Congress, President's authority. It is cabined, I bet. President's authority to. So they're basically saying that the Trade Act curbed the president's ability to impose non-state of emergency. Another reason. Under it, the IEEPA's powers are available only where all of the following conditions remain. First, there must be a threat which has its source in whole or in substantial part outside of the plaintiffs assert the orders implementing the worldwide retaliatory tariffs do not meet the unusual and extraordinary condition. By the government's telling, the court cannot ever question the president's assertion that the IEEPA authority deal with an unusual and extraordinary threat. The government invokes the political questions doctrine under a controversy that is non-reviewable, where there is a textually demonstrable constitutional commitment of the issue to a coordinate political department, or a lack of judicially discoverable and manageable standards for resolving it. The court concludes, however, that the question of the scope is a judicially reviewable question of statutory construction that resolves in favor of the plaintiffs contending that the tracking tariff orders do not deal with an unusual and extraordinary threat. Those orders thus lay outside of the bonds of Congress's delegation authority to the. This says the political questions doctrine does not preclude judicial review, tracking orders, and compliance. Political questions doctrine bars judicial review in a number of different scenarios. Prominent on the surface of any case held to individual to involve a political question is a textually demonstrable constitutional commitment of the issue to coordinate political department, or lack of judicially reviewable, discoverable, and manageable standards for resolving it, or the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion, or the impossibility of the courts undertaking independent resolution without exercising respect to two coordinate branches of government, or an unusual need for unquestioning adherence to political decision already made, or the potentiality of embarrassment from multifarious pronouncements by various departments on Jesus. Court clarified, however, that this is not a doctrine of political cases, and that is an error to suppose that every case or controversy which touches foreign relations lies beyond judicial cognizance. The government argues that two Baker factors preclude the court's review of whether the challenged tariff orders are permissible. The government asserts a profound lack of discoverable and manageable standards for resolving the validity of the president's threat assessment, also the impossibility of deciding without initial policy determination a clearly non-judicial discretion. This reliance on the political question doctrine is misplaced. The court can manage the standards for applying, dealing with an unusual and extraordinary threat language, just as it manages for the standards of any other statutory enactment that contains independent executive action. Under the Constitution, one of the judiciary's characteristic roles is to interpret statutes, and we cannot shirk this responsibility merely because our decision may have significant overtones. Even when it goes unmentioned, this principle is a common feature of statutory construction. Conclusion. Let's read the conclusion. The court holds, for the foregoing reasons, that the IEEPA does not authorize any of the worldwide retaliatory or trafficking tariff orders. The worldwide and retaliatory tariff orders exceed any authority granted to the president by the IEEPA, regulate importation by means of tariff. Tracking tariffs fail because they do not deal with the threats set forth in those orders. This conclusion entitles plaintiffs to judgment as a matter of law, as the court further finds no genuine dispute to any material fact. Summary judgment will enter against the United States. The challenged tariff orders will be vacated and their operation permanently enjoined. There's no question here of narrowly tailored relief. If the challenged tariff orders are unlawful to the plaintiffs as they are unlawful to all. So they basically said no injunction for you guys because we're injuncting it all. It's illegal. Got injunct.
60 days.
Huh?
That's how long the pause is. 60 days.
What happens after 60 days?
Well, then the tariffs go back into effect.
Why would they, if it's an unlawful delegation of power, why would they only pause it for 60 days?
Because I'm pretty sure that's the limit of their injunction power. Otherwise, it has to be Supreme Court in order to be permanently enjoined. Remember correctly? Plus, they've already ticked the Supreme Court off with their national injunction, so they're probably not wanting to push their limits. Pretty sure that's what it is. I just know there's a 60-day pause for something, or 60 days probably to appeal.
I think they appeal.
Then it is likely a 60-day pause.
Because, I mean, the plaintiffs were seeking an indefinite pause.
Weird.
Yeah. The challenge tariff orders will be vacated and their operation permanently enjoined.
It's weird. Then what's the 60-day thing for that was in the order?
Day thing in this order?
Unless I read the wrong thing. Did I read the wrong order?
Did maybe.
I think I read the wrong order. Then again, I have like 5 of them pulled up.
I mean, it looks like this is already being appealed. So
Ah,
I guess we'll see how that plays out. But
indeed.
yeah, no more tariffs for now, I guess.